Oh, yes. I was reading this from the United States Department of Education, Office of Civil Rights. Yes. This is an insurance of compliance civil rights certificate. Yes. The Title 6 of the Civil Rights Act of 1964. Yes. Then there's Title 9 of the Education Amendments of 1972. Yes. Section 504 of the Rehabilitation Act of 1973. Yes. The Age Discrimination Act of 1975, and the Boy Scouts of America's Equal Access Act of 2001. Yes. Now, it says here the applicant provides the assurance for the purpose of obtaining federal grants, loans, contracts, except contracts of insurance of guarantee, property, discounts, funds made available through the United States Department of Education or other federal financial assistance from the department. This assurance applies to all federal financial assistance from or for funds made available through the department, including any that the applicant may seek in the future. Yes. Now, this assurance of compliance, yes, this is something I didn't really read it until last night. I actually did send an email from the library after the study room. Yeah. I did my research and I found that Spokane County, the actual courtroom rules say that the respondent has 12 actual days, not judicial days, before having hearings. Yes. And has to respond in 7 days before the hearing, and that would be actual days. Yes. But they have to have a reply 3 judicial days before any of the hearings of a dissolution of marriage. Yes. Now, when I was reading that Judge's Guide to Domestic Violence, yes, I realized that there was no possible way that you could have a settlement conference setting hearing, yes, in 10 judicial days, because I put the actual court rules of Clallam County on my drive, and I didn't see that those court rules defined how long the petitioner had to serve the respondent before the next hearing. Yes. How long the respondent had to respond before the next hearing, and if either party would reply to the court that they're going to be there or they're not going to be there. Yes! And in the email, I thought, well, let's go through all the court rules of every judiciary in every county of the United States. It seems this concept of due process, where notice and opportunity to be heard has to be given to all the parties involved in a case. Yes. Well, part of that notice is the responding of a party that they received notice, yes, and then the proof of service in the court file before having the actual court hearing, and that's known as the reply in family law lingo. Yes. And my thought was, well, for every court in every county that does not have rules of family law of exactly how many days you have to serve the respondent, yes, how many days you have to have between court hearings, yes, there is no possible way that 10 days is the necessary number of days. Now, when I did just a brief estimate, because I can go through the rest of the court rules of every county of the state of Washington myself. Yes, you can. I thought if Snohomish County is 12 days, yes, and Spokane County is 12 days, and King County is 14 days, and you have to give the respondent 7 non-judicial days, that would include holidays, Saturdays, and Sundays, to be able to respond to the notice of the hearing, and then either the petitioner or the respondent has to reply to the court at least 3 judicial days, not inclusive of Saturdays, Sundays, and holidays. Yes. That every court rules must define exactly how many days you have for notice and hearing. Yes. Now, I think there's a big fraud going on in marriages, especially those that are the indigents. Pooch! Why don't you get me the PDFs of all court rules and all Word documents of all court rules? Because I am actually going to sue every court of jurisdiction that has a superior county court that doesn't define exactly how many days that I have as a respondent. Yes, how many days there has to be between court hearings so that the petitioner can serve the respondent. Yes, and then how many days that the court has to have for a reply so as to know that they have to keep it on the docket. There seems to be some people showing up at court not really knowing why the fuck they're there. Now, it would be interesting to note, yes, that somebody was using the Washington State Court website as well. He did know of the court hearing, but he didn't get any documentation. He wasn't allowed to prepare for court. Right. He didn't get the 2-count criminal complaint. He wasn't allowed to try to find some sort of pro bono legal help for himself. It's almost like, well, we don't have to give them notice from the state of jurisdiction that there's actually going to be a court hearing. Right. We don't have to obligate the petitioner to serve the respondent. We can sit there all day long as judges wondering why nobody's here because nobody has any fucking idea what the fuck is going on.